Greetings and salutations, my fellow sovereigns. This is the Saturday night Civics and Sovereignty class for the Vocational Science of Freedom. Tonight we'll be covering 1215.org, which is Bill Thornton's website dedicated to common law and sovereignty. We'll be doing a deep dive, going through all of the aspects of the site, how you can navigate it, and what you can learn from it. So, without further ado, I'd just like to introduce everyone to Bill Thornton. Now, what I typed in the top here in just the YouTube search bar was Bill Thornton Sovereignty. And if you click on that, what will come up are many of his lectures that he's done face-to-face, either audio and or video. I would suggest watching this one first, this Intro to Sovereignty. And as you can see, there's many different lectures from Bill Thornton. And when I first started learning law, Bill Thornton was the first gentleman who I learned from. And I spent a tremendous amount of time going over everything that's in 1215.org. And if you type in 1215.org in your search bar, this will be what you'll see when you first get here. And if you want to, there's two different ways to start going over the site. As he suggests here, step one, if you're new to the site, click here on start here and then follow the suggestions. And then two, if you follow the suggestions in step one, then click at the overview. Or you can just scroll down farther and then come down here to the pillars that he has set up. History, sovereign, republic, court, and then the corruption. So for starters, to say that you've never been here before, if you click on start here, what'll pop up is this little site. So if you're new to this site, before you begin, you should have a general knowledge of how this strategy works. If you are an attorney, please understand that herein is a completely different perspective on the law. This is not business as usual. Your education was primarily geared to equity law. That's statutes, acts, ordinances, and codes for anybody that doesn't know that. This site is primarily about common law, which is similar, but sufficiently different that to benefit from it, you must be prepared to revamp your perspective. If you are not an attorney, and you are uncomfortable about your knowledge of the law, consider purchasing the compact 2-day law course from Jurisdictionary. And there's a link right here. If you just click on it, it'll take you to the Jurisdictionary website. Though based in equity procedures, it will be a major help for you to understand the common law procedures. Don't be a part of the pro se problem. After absorbing that information, you should be ready to learn the advanced information here. And what he's getting at is that Jurisdictionary is a very, very good course, and I also suggest that everybody purchase it. It was also one of the first things that I purchased as per Bill's suggestion right from the website here. And I spent about 2 months doing every single day, going through step by step everything that's in the Jurisdictionary course. And Professor Greaves does a very, very good job at laying out how court process works. What is a motion? What's the first things that you file? What are the second things that you file? How does a court case proceed? What are the various different steps that you have to take in order to have your court case proceed correctly? And he also walks you through civil rules of procedure. Now, just to make a point, civil rules of procedure are the basis of Roman civil law, and they differ greatly from common law procedure, basically because in America we are sovereign and we can hold our own courts. Now, the government courts, the district courts, circuit courts, if you will, all of these courts are private for-profit entities. They all have their own Dun and Bradstreet number, and they have separate purses from the state. And what I mean by that is that they do not have 11th Amendment immunity. If they were actually operating via the Constitution and being part of the state, they would. But they do not because they have separate purses. And I have several court cases that a friend of mine, fellow colleague, sent to me that actually were given to him by a federal court judge, wherein when he was suing several different courts and several different judges and attorneys, they raised the argument that they had 11th Amendment immunity. Well, the federal judge said, no, you don't, because you have separate purses from the state. So that's just one of the important things to remember when you're understanding and beginning to learn about the difference between what is a common law court of record and what is a inferior court not of record, which is what all of those courts are, for the exception of a few. To give an example, one exception would be if you did an original action or an original writ, if you will, a high prerogative original writ in a state Supreme Court or in the federal Supreme Court. Another example of where you would be in a court of record is also in the United States Federal Court of Claims. That is also a court of record, and it's the only court that you can actually go and sue the United States in. And I could get into the history of that, but I cover it in the timeline class, which everybody can go watch on Odyssey under playlists, and then go down to the VSOF timeline class, and you can learn all of the history of how those courts were created. Okay, so back to the site here. Disclaimer, jurisdictionary pays referral commission. We do not accept any. Our referral is genuine, not influenced by money. Read everything in this webpage. As you progress, click on each underlined link and read the linked page. The linked page may have more links, but basically do not chase the links. Come back to this foundation. So after you get done with one, come back here, just hit the back button, and then come back and go on to the next one, right? Then look at the examples. They are from actual cases in Southern California. Once you have been thus exposed to the information, you'll be much more effective in our conversations. If you send email, be certain to mention something about the law or this website in the subject area. And if you click on this is a link to Bill Thornton's email. And I am not 100% certain, because I have had conversations with Bill Thornton many, many years ago over the phone, and we had a couple of phone conversations where it was a group conversation where we had many people join in. Okay, wise men are instructed by reason, men of less understanding by experience, the most ignorant by necessity, and the beast by nature. So that's Marcus Cicero. So he starts off with the Serenity Prayer, and it's just a short little prayer, simple thing, and health and attitude. Now the attitude part is where I'll start off at. Attitude is very important. Common law strategy will not work if you have a negative attitude. Many people who are defending their rights are also very angry. Now, that they are not justified. However, anger is a luxury of the poor, and as the saying goes, don't get mad, get even. The whole court process is about getting even. The reason the IRS does tax court judgments is because the judgment is perceived as a compensation for what you lost. For example, if you were falsely incarcerated, that time in jail has a monetary value. The monetary judgment you receive is a monetary replacement for your injury, namely for the rights you lost. You need to psychologically detach yourself from your problem. If you don't, if you are too close to your problem, you'll be blind to your own options. Your mind will be channeled, and you won't see other opportunities to win. So basically what he's saying there is you have to look at your own court case as if it were someone else's. Grammar, logic, and rhetoric, basically pure raw reason. And logically go through step by step what court process is and know what you need to present in order to win. But remove your emotion from it. That's what he's getting at, okay? So have you ever bought a car? Always a good emotional experience. Did you notice that after you bought your car, how many other cars on the highway were just like yours? Those other cars were there all the time. But until your mind was focused by your purchase, you were not sensitive to their presence. So it is with law and strong emotions. If you're full of anger or always extremely happy, your mind will be focused upon the stimulus, and you will not be sensitive to other factors. The angrier you are, the more opportunities you will miss. So that's just an aspect of attitude, and it's very important. And again, at the bottom, don't let your emotions entangle your logic. So make sure that you keep your emotions out of it. Next part is Introduction to Common Law. This is lectures that you can just download. All you have to do is click on the session here, and then it'll pull up a recorder, which it'll actually play, but you can just right click on it and then hit download. And I highly suggest that everyone download every single audio that's on 1215.org. I have probably listened to all of the audio that's on 1215.org at least, and this is not a joke, at least 100 times. It was the only thing that I listened to in the beginning because it was the only thing that I could find that helped me learn common law. So I listened to it over and over and over. And I took notes, and then I started doing my own research based upon what I learned here. Okay. Next section, language and dictionaries. Which English language do you speak? And I'm going to blow this up because it's a little bit small print here. So this is a quote from 1984. How's the dictionary getting along? Winston asked his comrade, Steamy, who worked with him in the research department. We're getting the language into its final shape, Steamy answered. By the year 2050, at the very latest, not a single human being will be alive who could understand the conversation we are having now. So the point is that they change language. Now, legalese, or the language of law, if you will, changes very, very slowly. However, when you're looking and reading statutes, they can write a statute however they want, and they can define words within the statute that are actually different than the definitions of the words that you would say go and look up in Black's Law Dictionary. They do this all the time because in statutory construction, what the attorney is trying to do is try to manipulate market conditions, try to get that 35% out of whatever situation is going on at the moment, based upon political ideologies, based upon whole different ideas. And what I'm getting at are things like, okay, how can we make money off of environmentalism, which is basically the attorney taking their 35% from corporations who violate the environmental statutes. Or the biggest one would be, in a sense, capitalism itself, because the definition of capitalism is different than a free market system, which is why you usually see the term free market capitalism. It's two separate ideas. Capitalism, if you break down the word from an etymological standpoint, cap or capit means head. So capitalism is a system that derives a value off of your head. That's why you're called a human resource. So what the attorney does is they alter the statutes based upon market conditions of all these various different things so that they can always get their 35%. I mean, there's a reason why divorce court and divorce lawyers are so prevalent. It's because they've created a situation where that makes them a lot of money. So, to continue, in America, we speak three languages: slang, formal English, and legal English. Though similar, if one tries to communicate using one language while the listener is listening using another language, there is great opportunity for miscommunication. This article was written in legal English. So first, slang. It's a language of the street. It is dynamic, loosely defined language. It can vary considerably from one geographical area to the next. It abounds with special and paradoxical interpretations. One must grow up with the language to fully appreciate its particularities. Foreigners always have great difficulty dealing with the various idioms. For example, if you think something is genuinely wonderful, you could say either, "That's really cool," or "That's really hot." Another way to express great approval is to exclaim, "That's bad," or "That's good." Formal English. Precise communication requires a more formal structure. Formal English is taught in the schools, and it is the language of choice when strangers meet to execute common transactions. It is a stable language that typically requires multi-decades or centuries to evolve its meanings. And where you will look up formal English would be in formal dictionaries, like Webster's 1828 dictionary, the Oxford English Dictionary, and so on and so forth. Legal English. When you want accuracy in communication, legal English is the preferred language, also known as King's English or the language of the courtroom. Legal English is extremely stable, requiring thousands of years for changes in meaning, for the exception of what I was just speaking about regarding statutes. Okay, Because accuracy is required for good legal communication, legal definitions tend to be rather verbose. The extended explanations are necessary to achieve that accuracy. Legal dictionaries are not called dictionaries. The more thorough dictionaries are entitled corpus juris and words and phrases. And, just to make a point here, the entire words and phrases, all of it, is on the Vocational Science of Freedom members only online library. So if you're a member of the Vocational Science of Freedom, you have access to all of these books. You can download them right off the mega links. And if you'd like to become a member of the Vocational Science of Freedom, click on Prices and Membership to learn how to become a VSOF member. So, to continue, later editions of Bouvier's Law Dictionary are more like legal encyclopedias. Black's Law Dictionary, 5th through 7th editions, well, it's now all the way up to 11th, are not as accurate because references to common law are progressively removed, and Roman civil law concepts are augmented in order to conform to the law enforcement needs of political power centers such as the federal government and the United Nations, which is exactly what I was just explaining regarding how the attorneys alter market conditions. That's what he's talking about. The rule of thumb is that the older dictionaries are useful for understanding natural rights, common law, personal sovereignty, and the people's point of view. Newer dictionaries are useful for understanding civil rights, Roman civil law, centralized authority, and the government's point of view. All attorneys are trained in the latter. Judges may go to special seminars to learn the former. You, listening to this now, can come to the Vocational Science of Freedom to learn the former. Also, come to 1215.org and learn everything that's here. That's where you learn your common law, your natural rights, your personal sovereignty, and the people's point of view. This also, in a nutshell, what he just said here, is the study of civics. Now, I know civics, in a sense, kind of sounds like, civil is civil law, but the learning, the study of civics, is the study of one's personal rights. And that's why we hold these classes every week. To continue, for an excellent research paper on the use of dictionaries in the Supreme Court of the United States, see Kevin Warbach's Looking It Up, the Supreme Court's Use of Dictionaries in Statutory and Constitutional Interpretation, 1994. And again, all these links are available, so if you go click on it, you can go get the book. Government manipulation of language, source, natural person, government tricks. So, government tricks. And this is everything, again, this is what the attorney does in the standpoint of statutes, again, how they rewrite things. So, first trick. The first trick of government is the redefinition of certain critical words in each statute or act. They, the government, want you to assume the ordinary meaning of the word so as to trick you into reading and interpreting the statute in their favor. Here is a summary of some of the trick words. Two key words that are redefined in almost every statute are the words person and individual. There are at least two person in law. Natural person, which is a legal entity for the human being. An artificial person is a legal entity that is not a human being. Now, natural person. A natural person is a human being that has the capacity for rights and duties. Another way to understand natural person is that it's an infant, because an infant has a capacity for rights and duties, but doesn't necessarily ever exercise them. Now, in contrast, I just want to show something else here that's important as far as a definition is concerned. And it's the definition of person in USC Title I, subsection 8. And I'll put this in the chat as well. So, the definition of person. Now, this is for everything that the Congress does. 1, USC, subsection 8, person, human being, child, and individual. So, all of these things, all of them, are going to be the following. And again, keep in mind, this is statutory construction. This is how they do this. A, in determining the meaning of any act of Congress or of any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States, the words person, human being, child, and individual shall include every infant member of the species Homo sapiens who is born alive at any time of development. Now, an infant is a decedent of an estate or grantor, owner or trustor of a trust, guardianship, receivership, or custodianship that has yet to receive a Social Security number. This is in the IRS manual. Now, of course, the IRS manual has all of its own definitions as well that are not necessarily the same as the statutory ones. So the IRS does their own trickery. But the point is, in statutory construction, where it says the word shall, there is a maxim of law that states, well, it says shall include. So shall is something that means it's absolute instead of may or must, because must and may are the same thing. Shall is absolute in statutory construction. Include, and this is the point, there is a maxim of law that states the inclusion of one is the exclusion of all others. So when you write something in law, in Roman civil law, and you state such and such shall include A, B, C, D, it automatically excludes all the rest of the alphabet. Okay, anything else that it could be. Another example is if I were to write a statute that says trees include oaks and elms, period. A pine tree would then, by definition of that statute and use in that statute, not be considered a tree. This is how they do this. So when it says shall include every infant member of the species Homo sapien, a person is an infant. A human being is an infant. A child is an infant. An individual is an infant. That's what it means. It means an infant. Just understand that. And that's exactly what he's talking about here. But he's saying from the standpoint of natural person, artificial person. But you get the point. So, an artificial person, a legal entity, not a human being, recognized as a person in law to whom certain legal rights and duties may be attached, i.e. a body corporate, so corporations. You will observe that the natural person has the capacity, i.e. ability, of rights and duties, but not necessarily the obligation, or even the knowledge of how to exercise them, I would add. The artificial person has rights and duties that may be attached, i.e. assigned by laws. Second trick. The second trick of the government is to use the Interpretation Act to define words that apply to all statutes, unless redefined within a particular statute, which is the example that I just gave everyone. Without this knowledge, you could assume the ordinary meaning of the words you are reading, not realizing that they may have been defined by the Interpretation Act. Unless these words have been redefined in another statute, the underlying definitions for the two most important words still apply, either from the Interpretation Act or the Canadian Law Dictionary. Basically, they are defined as follows. From the Canadian Law Dictionary, we find individual means a natural person. From the Income Tax Act, we find the redefinition, individual means an artificial person. So, right? Two different things. So you always have to go and look up the definitions, which will always be, well, usually always be, in the beginning of the act or the statute. Third trick. The third trick of government is to use the word includes, which is what I was just telling you about, in definitions instead of using the word means. They do this in some critical definitions that they want you to misinterpret. If they used means instead of includes, then their description would be exposed, but by using includes, they rely upon the reader to assume that includes expands the definition. It does not. Whereas in reality, it restricts the definition in the same manner that means restricts the definition. Here is a means definition of the word person from the Bank Act. Person means a natural person, an entity or personal representative. Here's an includes definition of the word person from the Interpretation Act. Person, or any word or expression descriptive of a person, includes a corporation, right? So here in the Interpretation Act, a person is only a corporation, right? Because it says includes, and then whatever's after the word includes, that's it. That's all it means, nothing more. Because as he said, it's not and also, which is how most people would interpret the word includes. They'd say, oh, so something includes this, that, the next thing. Okay, so here means and also this. No. Includes means this and this only. That's what it means. So to expose their deception, substitute the word means, and you have person and any other word or expression descriptive of person means a corporation, vis-a-vis an artificial person. Both means and includes are restrictive in scope because they only encompass part of the whole. Typically, they are used in the following forms. Person means A, B, or C, and nothing else. Person includes A, B, and C, and nothing else. So again, back to the definition. Person, human being, child, and individual shall include every infant member of the species Homo sapien. That's all they're doing. That's all they've ever been doing. And that's what I have told everybody over and over again. It's the main thing that you have to learn about this slavery system. They are administering infant abandoned estates. That's what they're doing. And that's all they've ever been doing because it's all they could ever do. They can't force the sovereign to do anything, but they certainly can administer infants because, ancient aspect of law, the king, or whatever the ruling government is, has the right to administer and protect infants, lunatics, and bankrupts. That's never changed. Never will change, be my guess. So, what is the United States Federal Corporation doing? They're administering abandoned infant estates. That's why they have to label everybody an infant. So the way out of that is to do your Vocational Science of Freedom status doc set and correct on the public record that says, no, I'm not an infant. I have come of full age, which is how it's specifically written in the common law, which goes all the way back to the Magna Carta at guess what date? 1215. 1215 AD was when the Magna Carta was signed, and that's why Bill Thornton created this website named 1215.org, because it's the basis of the common law. And if you go back and read Article 3, 4, and 5 of the Magna Carta, you will see exactly what the remedy is. It's been there for over 800 years, and yet no one has been paying any attention to it. But they've done this over and over and over. They've continued to put presumptions on us that then throw us under the bus under Roman civil law. Your duty and your requirement as a sovereign is to rebut the presumptions and say, no, I am not that, I'm this. And the only way that you do that is by declaring what you are, not what you are not, because you cannot prove a negative, right? And that's everything that's covered in the Vocational Science of Freedom status doc set. And if you guys want a quick overview, take a look at it and what it means and how we do it, go watch this class, VSOF Status Docs Overview and Explanation. It's under Correct Your American Status and VSOF Paperwork. I would suggest actually watching all of these in order, but this is the class where we cover the Vocational Science of Freedom Status Docs and what they do, how they correct the public record to get rid of all these bloody presumptions and remove all of this Roman civil law that they're trying to put over top of us. Okay, to continue. Fourth trick. The fourth trick of government is to modify how the word includes is used in order to make an expansion in the definition when such expansion is required. This trick helps add confusion to the use of includes, convincing most readers that includes should always be expansive rather than limiting. And this is how they do it. So here are some legitimate ways in which includes is modified to become expansive rather than restrictive. Also includes, and includes. Includes without limitation, including but not limited to. This is the one that I always use if I'm writing something. If I want to state something specific in a paragraph, but not limit it to what I said in the paragraph, I always use that one. Including but not limited to. So it means that I'm not excluding anything else by using the word includes. So that's how I do it. And it just makes more sense than the rest of them above, I've found. And it also is the one that's more common as well. So includes but is not limited to, or including but not limited to. The expansive definitions usually take the following form. Person means A, B, or C, and includes D. So now it's A, B, C, and D. However, there is a possibility that and includes is restrictive in some constructions. There are some people investigating this possibly right now. Their logic is demonstrated by the following example of a definition that states, Providence means a province of Canada and includes Ontario and Quebec. So I'm just going to leave it at that. You guys can read the rest of this and understand that. And it took me a while to wrap my head around it because it's not instinctually understandable. It's not really logical what they're doing. And of course, that's the reason, because they want to confuse you. So, again, just go over it as many times as you can until you wrap your mind around it. But hopefully I gave you guys enough good examples tonight that makes sense to you. So now, definitions. Barron's Canadian Law Dictionary does not provide definitions for, include, or means. Surprise, surprise. Therefore, we have to look in the next source for the definitions. From Black's Law 4th edition, here's a definition for the word include. Include, to confine within, hold as in an enclosure, take in, attain, shut up, contain, enclose, comprise, comprehend, embrace, involve. Including may, according to context, express an enlargement and have the meaning of and, or in addition to, or merely specify a particular thing already included within general words theretofore used. So, again, I go by the maxim, which states that the inclusion of one is the exclusion of all others. I always go back to maxims because the maxims are, in law, the highest authority that you can take over thousands of year periods of time, because maxims do not get created yet by going and having the same thing done over and over and over thousands of times for hundreds or even thousands of years. So that's where maxims come from, and maxims are an important part of the common law. So that's a little bit of word trickery, and I'm just going to click backwards. So again, click back to go back. I'm going to make this a little bit smaller. So that was language and dictionaries. So honor and dishonor. This is the most important aspect of the law. In law, honor and dishonor is a process. It is what is done in response to a presentment. Throughout the entire process, you must be in honor. This applies to everything you do in legal process. To act with dishonor towards the other person is the highest sin in any system of law. Now, just to be very clear, just use this little graph. So in practice, 3 ways to honor presentment. Accord and satisfaction. That means, yep, I agree to what you said, and here's your payment, right? Or here's the thing that I said I was going to do in the contract, whatever it may be as far as the satisfaction is concerned. 2, conditional acceptance. This means, hey, I'll do the such thing that you wanted me to do on the condition that you will do this thing for me, or that you will do this thing. That's conditional acceptance. Rejection without dishonor. And this is just basically saying, hey, I got your notice, I read it, and I'm rejecting it without dishonor because these are the things that are incorrect within the presentment itself. And a good example of that, as far as a court case would be concerned, is, say, the state files a court case, and of course they're always filing it against your estate name, and you file what's called a plea and abatement. A plea and abatement is saying, hey, wait a second, I don't know who or what it is you're suing here, because that, all capital letters name, that's not me. That must be a constructive trust, or it might be an estate. I need to know what it is. And a plea and abatement stops everything at the beginning. And it says, hey, stop. Who or what are you suing? Because unless I know who or what you're suing, I can't answer your suit. I can't even begin to formulate a proper argument against it, or a proper response or reply. It should be. This is a better way to say it. So I can't answer the suit unless I know who or what the hell it is that you're suing. So you have to answer me and tell me who or what it is you're suing. And we've done some interesting plea and abatements that got some really interesting answers. In fact, there was a judge and a district attorney that actually admitted in open court that the defendant was a constructive trust. And that's not the first time that's happened. But the only way you get them or force them into agreeing or saying what it actually is with a plea and abatement. So that would be an example of rejection without dishonor. You're saying, hey, I'm rejecting the suit because I don't know who or what the hell it is you're suing, right? So the 2 ways to dishonor presentment are argument and silence. Now, what he means here by argument is the standpoint you're just arguing back to them, say something like, oh, I don't owe you anything, blah, 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 because you're an asshole, right? Some kind of ad hominem attack or something like that. Or silence is that you never reply back to them at all, which is why I always tell everyone that if you ever get anything in the mail from a corporation, I don't care what it is, write up a notice back to them. Write up a notice with one of the 3 that's on the honor side. Conditional acceptance, rejection without dishonor, so on and so forth. Some of the best paperwork I've ever seen written regarding that process is Cal Washington's paperwork that he does with the Empower movement. The way he does those notices back to the power companies regarding smart meters and puts them on notice that they're literally causing him or whoever writes the notice, a damage, harm, loss, and injury because of the radiation that comes off the smart meters. The way that he does that and the language that he uses is top notch. I've not found, and actually I took examples from some of those notices and have actually incorporated some of that language, some of the contractual language, into the Vocational Science of Freedom status doc set because it was written in a very, very clear and concise way. So again, I get a good example of that. Go check out the Empower Movement and read Cal Washington's Notice of Liability, which is basically a way to, you're the one starting the presentment. So he starts the presentment in honor by saying, hey, you guys, you're causing me damage, harm, loss, and injury, and here's your notice of liability, meaning that you are liable for the damage that you are causing me, and you are not immune from suit. And here are the reasons, and then he lists everything in there. So, okay, so honor, accord and satisfaction. CD honors by accepting the presentment without recourse and then satisfies whatever is demanded in the presentment. As I said, pays the bill, whatever. Conditional acceptance. CD honors by accepting the presentment, but with conditions. Effectively, it is a counteroffer from CD to AB. AB would then accept or counteroffer as a new presentment from CD. So example, AB offers his house for sale. CD accepts offer provided that the house is first painted. Right? So I'll buy it as long as you paint it. So that's a counteroffer. So basically conditional acceptance is the same thing as a counteroffer. So just remember that. Rejection without dishonor. CD rejects the presentment because it is defective. As in the example, who or what in the hell are you suing? Right? Plea and abatement. AB presents a bill for services. CD returns the bill because there is an error. Perhaps the price is wrong, but will accept the bill once the error is corrected. Right? And you will answer the suit once you tell me who or what it is the hell that you're suing. Right? And that's what the plea and abatement. Then dishonor. Argument. So CD rejects, dishonors the bill. There's no basis for rejecting the bill. The arguments have no relevancy to the presentment. Often ad hominems, irrelevant comments against AB, accompany the rejection. As I said, you're an asshole, whatever. Or 5, silence. CD simply does not respond to the presentment but remains silent. The presentment is thus dishonored. This is what the IRS does to people all of the time. The IRS sends you a notice. Says, hey, we think you owe $50,000. You're like, that's insane. I don't know $50,000. There's no way I owe $50,000. Go to hell. But you never, ever send them a notice back saying, this is clearly incorrect. There's no possible way I could possibly ever owe that. And furthermore, I'm not a taxpayer. Or whatever it is you want to say. Instead, what people do is they take IRS notices and they throw them in the trash. That is a dishonor because you didn't reply. You remain silent. Well, guess what? All the IRS has to do is to send you 3 notices and then a default notice. And that is what is called an administrative procedure. If you do an administrative procedure against someone, you're then categorically, by the presentments that you're doing, putting them into a place of dishonor, which you can then take to a court and have it judged by entering those presentments into evidence onto the record. Now, a lot of people have fucked this up. There are a lot of people sitting in federal prison right now, and I could name some names, but I won't, that think that after you do an administrative procedure, that somehow that is a judgment. It is not a judgment, nor will it ever be a judgment. There were some people, and again, I won't name names, that were doing administrative procedures correctly, but then they were turning around and they were putting liens on judges' houses or district attorneys' houses or sheriff's houses based upon the dishonorment of the administrative procedure, which is the 1, 2, 3 notices saying, hey, you're stepping on my toes, get off my toes for these reasons. And then finally a notary presentment of default saying, hey, I've noticed you 3 times, you're still stepping on my foot. Here's a notary giving you a default notary presentment, of which then you obviously have signed and sealed by the notary, and then that's what you take to court. Well, they were thinking that these were judgments in and of themselves. They're not judgments. Judgments can only come from a court. Awards can come from a binding arbitration proceeding. You get an award from a binding arbitration proceeding. You get a judgment from a court. And you just get a default from doing an administrative procedure. So, and this is what he's talking about here, procedure. AB makes a presentment to CD. If CD honors the presentment, AB acts accordingly. As long as each party honors the other's presentments, the process can move forward to resolution, which means you don't even have to go to court. If CD dishonors AB, then AB grants grace and repeats the presentment. That's like your first notice. You're saying, hey, first notice, this is what I need you to do. I'll give you a 90-day grace period to do it, which is usually the time period that you give government entities. With men and women, 30 days is sufficient. And I believe most statutory requirements in the state level, in state statutes, I believe is 28 days. I don't know why they made it 28, but anyway, sometimes it's 27. But if you just say 30 days, you're good with men and women. And then if you want the government to do something, give them 90, because they don't obviously act that quickly in anything they do. This is number 3. So if CD dishonors AB a second time, AB then makes an affidavit of the history of presentments. The affidavit is given to a notary public. The notary is requested to make, in behalf of AB, a formal presentment to CD. So now you're having the notary give them formal presentments in the mail. If CD, because here's the thing, notaries are considered to be officers of the court, right? Now, yes, they're technically an ecclesiastical position, and yes, in a weird way, they're kind of sort of dealing with the dead. But if you want to deal with stuff in equity and you want to just absolutely crush someone underneath your boot heel, this is what you should be doing, because once you default them, they're basically fucked. Which anybody knows who's ever been to IRS tax court, and you are the one that's in dishonor. You're guilty the second you walk in the door, because it's already over. Because it all happened before going to court, and that is the point. So number 4, if CD dishonors the presentment, the notary grants grace and repeats the presentment. If CD dishonors the notary a second time, the notary makes a certified history of the presentment. The history is given to AB. At this point, AB and CD's administrative procedures or process is complete. The affidavit of AB, along with the certificate from the notary, now becomes the basis for a court action against CD. Right? So this is your administrative procedure, but then you have to take it to a court. This in and of itself is not a judgment. In court, you can think of court process as a formal series of presentments. Each time a presentment is made, i.e. a court paper is filed, the responding party has an opportunity to honor or dishonor the presentment. That goes even with motions. One party files a motion. They give notice to the other party, hey, I filed this motion. I'm going to move the court to do whatever. The other party has a responsibility and a duty and an opportunity to argue their side why the court should not grant the motion. And this is what happens in a motion hearing. This is all this stuff that you do before you go to trial, which is all explained in jurisdictionary. Okay? Now, I've also explained it in the VSOF class of the totality of law class and the ins and outs of court class. Take a look at those. Because court process is a very, very specific thing, and you need to understand how this works, how the back and forth goes. And to make a silly analogy, think of it literally like a tennis court. What does one guy do? He hits the ball over to the other guy's court. What's the job of the other guy? Hit the ball back to the other guy's court. It's a game of back and forth, back and forth, back and forth, back and forth, until you eventually get to a point where you say, okay, we're at an impasse here. I say X is an elephant, and you say X is a duck. Well, now we bring it to a court, and a jury of 12 members of the peerage decides whether it's an elephant or whether it's a duck. That's how the whole process in a nutshell works. Okay? So to continue, the response, whether honorable or dishonorable, in turn becomes a presentment. Your objective is to never dishonor the other party's presentment. If the other party persists in argument or silence, you can stay in honor by refusing his arguments for cause, stating the cause, and giving him opportunity to cure the defects. Again, good example is a plea and abatement. If he refuses to stop arguing, you stay in honor as he continues in dishonor. Another point to be made here. When you are laying down whatever it is as far as your arguments and your presentment are, and you know you're right, never, ever let the court move on until your arguments are heard and until they answer your presentments. If the court moves on without forcing the other side to answer your presentments, or say, for example, ignores a motion that you filed, never hears it, and well, the thing about motions is you need to contact the judicial assistant, and which every judge has one. It's basically the person that holds the calendar for the judge. So you contact the judicial assistant, you say, hey, I've got a motion filed. Yes, I sent it to the other party. I need a calendar date to have this motion heard in court. The judicial assistant will usually say, okay, I've got Tuesday on the 25th of July. Does that sound good for you? And you say, okay, great. What time? And say, okay, 9 o'clock in the morning. Okay, wonderful. Do you need me to inform the other side or the other party? And usually the judicial assistant will say, no, I'll call the district attorney or whoever the hell it is you're going up against. And usually if it's a state agent, then the judicial assistant will usually contact them on their own. But if it's a party, just another sovereign or just another people that you're suing, then you'll probably be the one that will have to contact them, send them a notice and say, hey, I filed this motion. I sent it to you on such and such date by the mail, and it's now scheduled for calendar on yada yada date at such and such time, whatever. So never let them move forward unless that point has been settled or has been overturned or has been ruled upon. Another word to use, or they use in court, is called passed. So has the motion passed, or has the court passed on that motion? Has the matter of jurisdiction passed is another way to say that, meaning has the court ruled yet that it even has jurisdiction to hear the matters before it, which would be obviously a motion to dismiss for lack of subject matter jurisdiction or lack of in personam jurisdiction or venue or any of the other multiple amounts of things that you can file a motion to dismiss for. Point is, do not let them move past your motion. And if they do, or if, say, they do not grant the motion and it's imperative that they do, or it would be detrimental for you to continue when they fail to grant the motion, they deny it, then what you can do at that exact moment, if you wish to, and this of course is equity proceeding, you can at that exact moment file what is called an interlocutory appeal and say, nope, I'm taking this to an appeal court. You guys are a bunch of idiots. You don't know what you're talking about. You do not understand the law. Someone who has more brains than you needs to look at this, because I will be injured if this continues and you're not paying attention to it. So I'm going to send it to somebody who will and who knows what's right and wrong here. So you do an interlocutory appeal and then you send it into the appeal court and you say, look, this judge denied this motion. There was no basis for denying the motion. And here's all the reasons and all of the case law and all the remedy beforehand from, however far you want to go back, time immemorial, that shows that he should have granted it. You wish that the appellate court reverse the denial of the motion or the ruling of the inferior court and force them to grant the motion. And then that would be how it would go back and forth. And again, all of this you learn in jurisdictionary. So again, get the course, understand it, understand court procedure. So to continue, so if the other party persists in argument or silence, you can stay in honor by refusing his arguments for cause, stating the cause, and giving him opportunity to cure the defects. If he refuses to stop arguing, you stay in honor as he continues in dishonor. And again, that's what you bring up to the appellate court. Hey, these guys are in dishonor. They're not doing what they're supposed to be doing. Now, parens patriae. This is a whole different matter. So parens patriae originates from the English common law, where the king had a royal prerogative to act as guardian to persons with legal disabilities, such as infants, idiots, and lunatics, and also, as I mentioned, bankrupts. In the United States, the parens patriae function belongs with the state. At least in theory, two reasonable contending people would honor each other and attempt to resolve the problem at hand. In actual practice, often, one or the other or both will act in dishonor. If both are acting in honor, the court has nothing to decide, for the parties will work it out together. Now, very interesting and very important sentence here. If both are acting in honor, the court has nothing to decide, for the parties will work it out together. There was one time, this was a traffic court case, actually my traffic court case. This was years and years and years ago. This goes all the way back to 1994 or something like that. I had a traffic court case, and in the middle of the motion hearing, I said, I think the judge might have asked me a question like, is there anything else you'd like to add or something like that? And I said, yes, Your Honor. I said, there has been no discussion about this matter. And he looked over at the district attorney and said, is that true? And the district attorney said, well, no, I didn't get a chance to return his calls and blah, blah, blah. And the judge threw up his hands. He said, okay, everything stops right now. He said, I don't have another case after this. He said, you guys are the last ones to go for the day. I'll stay here. You guys can talk it out right now. And he did. And that's exactly what happened. Because when you say in court, Your Honor, there has been no discussion about this matter, what you're saying to the court is, hey, I'd like to talk it out with the other guy, but he hasn't even replied back to me, or there's been no discussion. The court will instantly, and has to by law, instantly stop. It has to end, quit right there. It cannot move forward when you say that, because you're saying to the court, look, hey, I'll stay in honor, or I'll talk to the guy, or whatever, but there's been no discussion, and I would rather not waste the court's time to continue to go through with a court case if we can work this out. So, interesting court procedural note. Just make a note of that, because you can stop any court case dead in its tracks by simply saying that, because I've done it. I know it works. And anyway, the rest of the story of what happened about how the district attorney jumped out of their seat and ran over to me and gave me the best deal. And it was funny because she was like a low district attorney. And she said, this is the absolute best deal I can possibly give you as per statute. I said, well, why can't you give me a deal that's better than the statutes? Well, they won't let me. And I'm like, oh, okay. So if you want to keep your job, you have to follow the Roman civil law rules. Okay, I understand. And she's like, yeah, that is kind of where I'm stuck at. And then I contemplated whatever else. And I had her drop one other thing, and then I took a deal because I didn't particularly want to go through it. But the point is that she ran over and jumped literally into my lap was because I had filed something like 26 motions to dismiss. All of them were valid. All of them had strong arguments, and some of them were extremely detrimental to the entire court system itself. And what I mean by that is that I was proving the fact that they were private for-profit entities and were putting in their Dun & Bradstreet number, and I was showing them where I was going, and they didn't like that too much, and it actually scared the shit out of them. So, but anyway. All right, to continue. So, in actual practice, often one of them will both be in dishonor. If they're both acting in honor, the court has nothing to decide, right? For the parties to work it out together. If one party acts in dishonor, the court must look with favor towards the person who is in honor. If both parties are acting in dishonor, the doctrine of parens patriae becomes effective, meaning you're both infants, I'll decide whatever I want to decide. And that's usually what happens. The judge just sits up there and just acts like parens patriae. I'm like, okay, you're both acting like children, so I'll just do this. And then whatever he decides to do or say is literally like legislating law from the bench, but it's lawful because you're an infant. And here's the thing. The presumption is you're always an infant when you're in any of these inferior courts anyway. So that's the reason why you should never be in them. And if you correctly rebut the presumption and stay out of them and actually do all of your court stuff in a court of record where you're the plaintiff, which is exactly what 1215.org explains, you don't have to ever have that problem of being stuck as a defendant, as an infant, in an inferior court, not of record. So to finish this up, when both parties are in dishonor, either because they are arguing or confused or silent, the state now has full power to invoke parens patriae to control the affairs of the apparently incompetent litigants, idiots. So that's honor and dishonor. Now I'm not going to read all of the rest of these, but I'm going to kind of skim through this because we're already at an hour, and I do want to get through all this tonight. So, but like I said, remember guys, I told you this was going to be a long class. So if you want, you might want to pause it here, go get a drink, come back, if you're listening to this later. Okay. People or citizen, which one are you? This explains the difference between what is a people and what is a citizen, meaning a citizen of the United States, being subject to the jurisdiction of Congress. And this is a fairly short read, but this is analysis and understanding. It gives court cases, particularly Lansing versus Smith is a good one. In 1787, the people themselves came forward to ordain and establish this Constitution for the United States of America. See preamble. On September 17th, 1787, the states held a convention, and all those present unanimously joined in, and see the last paragraph of the Constitution. So in 1887, unanimous concurrence was achieved, and the Constitution was born, later to be ratified. And this is the aspect of the preamble. So we, the people of the United States. So we wrote this thing for the states to do what they did if they wanted to join in. And then if all the states joined in, then this thing was a go. But we, the people, ordained and established. Ordained means to create law. Established means to put it down on a piece of paper. This Constitution for the United States of America, right? And remember, the United States of America is the name of the trust which was created under the Articles of Confederation. So first the trust was created, and then later on, this thing happened where it was given a constitution. And there's all kinds of very interesting history about false flag aspects of, Shays' Rebellion and why this Constitution got pushed through when the Articles of Confederation was basically working just fine, and so on and so forth, but I won't get into that. Okay, so what are we doing here? So the structure of the preamble. Trustor, we the people. Venue, United States. Purpose, in order to form a more perfect union, establish justice, so on and so forth. Beneficiary, to ourselves and our posterity. Posterity means the heirs that come after us. The post-heirs, heirs after us, posterity. Enabling action 1, do ordain. Enabling action 2, and establish. What? This Constitution? Trustees for the United States of America. The trust, the original trust became the trustees of the Constitution that we created for them, right? So that's what he's saying. So the definition of citizen of the United States. Now that was people, now here's a citizen. Before ratification of the 14th Amendment, there was no legal definition of the term citizen of the United States. The term was used, but only generally. After the Civil War, the slaves were freed, but there was no legal basis for recognizing them as having any rights. The 14th Amendment partially solved that problem. Basically, all they did was they turned the slaves from being private property into being public property. Sorry to be bearer of bad news, but that's what they did. Free the slaves was the rallying cry combined with the Civil War that resulted in the Amendment 14th. The Amendment 14 created a new class of person called citizen of the United States. Any ex-slave could now claim citizenship. And, by the way, so could any of the people if they so choose to do so. Amendment 14 made possible the voluntary relinquishment of personal sovereignty. And I cover this ad nauseum in the timeline class. So, are you one of the people or one of the citizens? So the first issue to be resolved in any court proceeding is that of jurisdiction. Does the one entity have jurisdiction over the other entity? One should never go into court without a clear understanding as to whether he is there as a citizen or as one of the people. If you claim you are a citizen of the United States, then it is strongly implied, though not necessarily true, that you are subject to the laws of the United States. On the other hand, if you are one of the people, then it is legally implied that you are a legal king with a sovereignty superior to that of the United States, and subject only to the common law of the other kings, your peers. In short, the people are superior to the government is superior to the citizens. That is the hierarchy. So people, government, citizens. As a king, you are entitled to all the rights which formerly belonged to the king by his prerogative. And that's actually from a direct court case. You can do what you want to do when you want to do it. You have your own property and your own courts. There is no limit as to what you may do other than the natural limits of the universe and the sovereignty of a fellow sovereign. Meaning your rights end where the other guy's nose starts. You should treat the other sovereign in accordance with the golden rule, and at least must never harm him. Your sovereignty stops where the other sovereignty begins. You are one of the owners of the American government, and it is their promise that they will support your sovereignty, i.e., they have promised to support the Constitution and protect it from all enemies. You have no allegiance to anyone. The government, your only public servant, has allegiance to you, right? So that's people are citizen. Bill of Rights. This is the rights that are available to the people or to the U.S. citizens, but only privileges are granted to U.S. citizens, and he gives a list, so I won't click on that. Sovereignty. This is the aspect of what sovereignty is. There's many court cases in here and many showings of sovereignty, and I used some of these in the VSOF status docs. But one thing that Bill always tells you is that never, ever, ever use anyone else's court cases unless you go and check them yourself. Meaning that you've done your due diligence and you properly look up the court case. That's called shepherdizing, and you need to do that. This is the other important, or one of the other important lectures. So this is an 8-hour lecture series on sovereignty. Again, I can't tell you how many times I've listened to that. But again, all you got to do is click on the track, and then when the little player comes up, right-click on it, and then go to Save As. Republic versus democracy. Do you know the difference? The Army knows, and this is a link to a document that the official training manual number 2025 that was published when then the War Department, Washington, D.C., November 30th, 1928. And I believe this link still works, or at least I hope it does. Yep, so you can just download it and read it. And it tells everybody in the military what's the difference. California admission to the Union, a republic, not a democracy, which of course all of the states in the Union are republics. They're not a democracy. Common law, the concept, these are just good concepts to understand about common law and how to kind of get started as far as the understanding of it. A court of record. So this is where you start getting into court procedure. This is the understanding of what a court of record is. So this writer concludes from the definition below that a court of record is a court which must meet the following criteria. 1. Have power to fine and prison for contempt. 2. Keep a record of proceedings. 3. Proceeds according to the common law, which means not according to statutes, acts, ordinances, or codes. 4. The tribunal is independent of the magistrate. That's probably the most important one. The tribunal is the part of the court that makes the judgment. So, if the tribunal is independent of the magistrate, who is the tribunal in a court of record? And the answer is the 12-member sovereign jury of the peerage. When you are in a court of record, you can demand in a court of record from the jury what is called a general verdict. In a general verdict, the jury decides both the facts and the law, and that is what you want. Now, in a particular situation where possibly the defendant doesn't have the brains or the wherewithal to say, hey, I'd better convene a jury, or I demand my right to a trial by jury, and just goes along with a court of record, not realizing it's a court of record, thinking that it's an inferior court not of record, where the special administrator, black robe priest of El, sitting up on the bench, basically decides whatever they want. If they think they're in that court and they are actually in a court of record and they do not demand a jury, guess what? The tribunal is then the sovereign plaintiff himself or herself. You then are the tribunal in that court. You, the plaintiff. You decide everything. And if judge doesn't like it, tough shit. Hold him in contempt. Which, yes, you can do. And yes, 1215.org will show you how to do that. So, very important part. And 5 generally possesses a seal. Now, it says optional, but as far as I'm concerned, it's not optional. Because when you create your house seal, when you feel like doing the Vocational Science Freedom Status Doc set, you have to create a seal for your own house. And we have handbills that explain how to do that, so you can create your own seal. And then what you will do is you would use your own house seal as the seal of your superior court of record. So you get 2 things done at once. You create a house seal for yourself so you can seal your own documents and create covenants between people, which is what basically a contract is under seal. That's called a covenant, which is higher than just a regular contract. And you also then automatically created a seal for your own court. So again, this is just more explanation of what a court of record is. I'm not going to read all of that, but you can feel free to do so. And also see Nisi Prius Court, a court not of record, but a court by prior agreement. This is obviously what you're doing here. So in Black's Law, Nisi Prius Court defines as the Nisi Prius courts are such as are held for the trial of issues of fact before a jury of one presiding judge. In America, the phrase was formerly used to denote the forum, whatever may be its statutory name, in which the cause was tried to a jury as distinguished from the appellate court. To me, that says the Nisi Prius Court is a trial court of which is where the facts of a case are discovered. Thornton says a Nisi Prius Court is a court of record, but a record is kept in a trial court. Right. So your trial courts are your inferior courts. You're not saying a court of record, right? There's a difference. Because in an inferior court, what they're doing is that the judge decides the law and the jury usually decides the facts. But in any inferior court, in any equity court, in any court that proceeds according to statutory rules, the jury will never be allowed to decide the law. Never. Because they can't. Because all you have sitting there are 12 infants. Okay? So just know that. Court etiquette, some unwritten rules. This is extremely important if you guys have never read anything about court etiquette and how you're supposed to handle yourself, meaning dress, language, how you address the court, all very important things to learn. Habeas corpus, what it really is. This is extremely important if you want to file a habeas corpus for someone and you want to do it as per the common law and not as per a statutory habeas corpus, which will always get rejected. So also see Congressional Research Services overview on habeas corpus. And you can click on the habeas corpus handbook here, and this will walk you through how to do a proper habeas corpus at law and not in equity. Confirmare Cartarum, this is the charter which confirmed the Magna Carta, which was signed October 10th, 1297. And it's pretty much, as far as I understand it, has been signed by every king since then. to confirm that the Magna Carta is the beginning of the common law and is the Great Charter. And if you plead the Great Charter, that it must be considered to be the common law. And so this is the confirming charter. I also highly suggest that everybody read actually the Magna Carta to understand where it comes from. And I believe this, yeah, there's a hyperlink right here for the Magna Carta, so you can read that here, the whole thing. And just, and here's the point, since I have it already brought up, what I was talking about in Article 3, 4, and 5, they're right here. So I might as well just explain this to everyone. So Article 3, but if the heir of any of the above persons shall be under age and in wardship, when he comes of age, and in some translations it says when he comes of full age, but still, when he comes of age, he shall have his inheritance without relief and without fine. Okie dokie. So, if you're considered an infant, what that means is that you are not yet ready to administer your own estate, which means you are not capable to have the protections of the Constitution. Why? Because the heirs, the posterity, the heirs of us have that document as protection. If you do not come forward and prove that you've come of full age, then you do not have those protections. And that's why they label everyone as an infant. I know it's a very strange concept, but trust me, that's all they're doing. Number 4, the administrator of the land, which, okay, administrator, exchange that with special administrator or, black robe judgy poo, right? That's your administrator. The administrator of the land of such heir who shall be under age shall take none but reasonable issues from the land of the heir. So what you're saying here is that you can't fine and fee him to death for the use of his own property, even though technically that's what they're doing. But, and reasonable customs and services, and this without destruction of waste or men and goods. What the hell does that mean? And this without destruction of waste or men and goods. This is the reason why America has the highest per capita prison population in the world, but has some of the nicest prisons, as go for all of the rest of the common law former colonies of Great Britain. It's because they have to follow this, and without destruction of waste or men or goods. So when you have never, ever, ever actually claimed your estate, you're just the heir, but you haven't come of full age yet and claimed it, they have to keep everything without destruction or waste of men and goods. So when they throw you into jail, they have to make sure that you don't harm yourself and no one else harms you either. That's the point. And to continue, if we shall have committed the custody of any such land to the sheriff or of any other men who ought be responsible to us of the issues, and he cause destruction or waste to what is in his charge, we shall fine him, and the land shall be handed over to 2 lawful and discreet men of that fee who shall answer to us. So starts off with 2 men. If they mess up, gets passed on to 2 other men. Anybody want to take a wild guess at the 2 men that they're talking about? It's the judge and the district attorney. 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 They just keep passing and passing and passing and passing on your abandoned estate because you're not claiming it. So, or to him or whom we shall have referred them regarding those issues. And if we shall have given or sold to anyone the custody of such land, and he shall have caused destruction or waste to it, he shall lose that custody, and it shall be given to 2 lawful and discreet men of that fee, who likewise shall answer to us, as had been explained. Now, this is the last one, and the most interesting one that I feel. The administrator, moreover, so long as he may have the custody of the land, meaning administering all aspects of your estate, including your body, shall keep in order from the issues of that land the houses, parks, warrens, lakes, mills, and other things pertaining to it. And he shall restore to the heir when he comes to full age his whole land stocked with plows and wainages according to the time of the wainage, that's in reference to the waning and waxing of the moon, requires, and the issues of the land will reasonably permit. So what this says, what number 5 says, is that when the administrator is taking care of this stuff, he shall restore to the heir when he comes to full age. This means you're no longer a fucking infant. This is the reason why it's so important to get your status docs done, because unless you rebut that presumption, you never have title. Infants cannot hold title to anything. Nothing. Why do you think under all the Roman civil laws, it always tells you that you have to go register everything? Register this, register your car, register your guns, register your children. Right? It's because no one is actually acting as an heir and have come of full age to claim title. Another way to put this is that you have come to claim your birthright. So, just wanted to lay that out to you guys to show blatantly, obviously, what they're doing here. All right, all the way back. Now, it says Magna Carta, Interpretation of the Magna Carta. This is also a very good book. It's a whole book which gives interpretation of the Magna Carta. I've read it multiple times, which is why I can basically bring up any part of the Magna Carta and explain to all of you what it means. And last little part over here, upon completion of the instructions, study in the study example and 1215.org Q, which you can click on here. And these, I know the red is a little bit jarring to the eyes, but so these are aspects of strategy. Okay, so, and it's, again, this is difficult to see. So if you never click on this little part over here, you'd never go here, right? So this is the red part. So opposition to judges' demur, ruling on judges' demur, writ of error. This is where you correct anything that the judge has done against you in a court of record, where you are actually holding a court of record. Writ of error. This is, again, judges rescind order attached. How you do a judgment, plaintiff's ratification of all prior paperwork, and discharges, preservation of interest, meaning judge's home. This is where, you do liens and stuff on the judge's houses. And these are all just things you can download. Motion for indirect contempt. And you can hold the judges in contempt if they do things that you are not wanting them to do in your court of record because you're the tribunal, not them. Mandamus motion, notice of invalid ruling, action for trespass, quiet title. This one's good because this gives you a template for action trespass. Notice to clerk, file on demand. And this is where you're telling the clerks, nope, you have to file what I tell you to file, because there's actually part of the Federal Rules of Civil Procedure that says they actually have to do that if you are the plaintiff. They don't have to do shit for anyone who's the defendant. Okay, but if you're the plaintiff, that's a different story because it's your court. Here's a counterclaim PDF. That's very important. Make sure that you download the counterclaim. This is what you'd be filing against anything that comes against you, meaning any inferior court, cop, traffic ticket. This is where you start. Counterclaim and action for trespass. These two things are the things that you want to get done and grab the templates for, right? So rest the eyes there for a second. Okay, so you have to get done through all this. Then you go to the next page, click on here, and this gives you even more overviews as far as more documents to go read. So read me first, overview, foundation, and this is the duty of the aspect of what we're supposed to be doing here as far as the jury duty, so on and so forth. And example, this is where you see the entire case log of an example of a court of record. And each one of these hyperlinks you need to grab and download and then put them in order as to how you downloaded them from here. Okay? And you can read the transcripts. This was an actual case that Bill did. And aspect of jurisdiction. This is more lectures upon jurisdiction. Or I believe there's a lecture in here. I think there is. Is it under here? I think one of these has. I thought one of these had a audio. But anyway, it's more important understanding about jurisdiction and what it is, whether they have it or whether they don't. Jurisdiction cases. So these are a bunch of cases that show how, or when a court does not have jurisdiction, what they shouldn't be doing. So again, here, a court has no jurisdiction to determine its own jurisdiction, right? Notice that. For a basic issue, in any case before a tribunal, is its power to act, and a court must have the authority to decide that question in the first instance. And again, he's saying not check, not check, not check. So again, check all these cases. But again, always, always, always check your stuff. So like he says, always check all sites before using any of them in your papers. These sites have been checked, but when you use them, check them anyway. Mistakes happen. And yes, he's right, because I've even seen the Supreme Court throw in and use case law that wasn't correct. So anyway, you can read the rest of these if you like. So this is aspects of jurisdiction. So I'll back click and then back click again. And procedure. This is where it was in procedure. So here's the court paper forms and here's the lectures. So if you want to learn the aspect of what he's teaching you as far as a court of record is concerned, he focused and taught this for a very long period of time. Grab all the court papers, understand how this flow chart works here, how the action starts off and how it goes through everything, and then grab and listen to the forms lectures. This is how you prepare stuff in a court of record. Very, very important. PDFs are here. An action at law example. This is a good example for how you do an action at law. This is in a court of record, a superior court of record, how you do it. And you're going to have to learn how to write your own paperwork, which is part and parcel of what we teach the VSOF. Motions, motion lecture. Here's another 8-hour lectures just on motions. So again, listen to everything on this site. at least a dozen times. Common law court papers, sequence, seal, just an example of what a seal looks like. Counterclaim notes, what to do when you're in front of a judge and what not to do. So these are just basic things about why you object and how you're supposed to do it. So when you are in a courtroom, in a court of record, where you're the plaintiff, when everything happens in the courtroom that you don't like, you say, I object. Judge says, why do you object? It is not my wish. Well, judge says, if that's the best you can do, you're overruled. Well, Your Honor, for the record, I do object. All right, judge, your objection is noted, right? So if he keeps moving on with whatever he's doing, like say he denies your motion to dismiss, well, you wouldn't be dismissing something in your own court of record, but you get the point. If you file for final judgment, like they didn't answer the suit, they're just being stupid, they're trying to move everything in equity, and you're like, no, this isn't an equity scenario, and now you're out of time, and now I'm going to file for default judgment, and the judge says, it's denied, I'm denying it. You say, well, I object. Why do you object? Well, it's not my wish. If that's the best you can do, you're overruled. Well, Your Honor, for the record, I do object. Okay, your objection is noted. Then what you do is you file the writ of error, which I showed previous, where you did the writs of error, right? So you file the writ of error showing that the judge made a ruling which he didn't have any capacity to do. So you fix the court record. You fix your own court record. That's important. So common law court proceedings. Dismissal for failure to state a claim. This is what every single attorney always files first. So if you're suing them, expect this to be the first thing they file, a dismissal for failure to state a claim. It's what the first thing that they teach in law school, and it's just the boilerplate stupidity of everything every attorney always learns to throw in there. And the court may not dismiss your case because it is something that is above him, and he doesn't have any authority to do that. And Federal Rule of Civil Procedure Rule 8 simplifies claim requirements. This is for the aspects of doing stuff in federal court. So writ of error is used mainly to correct errors in a court procedure, e.g. when a clerk of a court of record accepts an order from a judge, that would be an error in procedure because a judge is not permitted to originate orders in a court of record. Only the tribunal, meaning only the sovereign plaintiff. A writ of error would order the judge's order to be rescinded, and there's examples here of writs of error for rescinding the judge's orders. And then petition for discretionary review, how to do a default judgment, which is what I was just talking about. Examples of strategy, press releases, how to do a press release. And this is important because you can also do this with a grand jury. Preserve error for appeal, the forgotten trial, how to handle the penalty phase. And this is the aspect of how you finish the case when it's finally over. And then the common law access to governmental records. So if FOIA didn't work, try this. So that's the procedure part, very important. And again, just remember to where we're at here. Remember, it's in this tiny little part here where it says 1215.org/Q. So just remember that. So then I'll back this up one more time. So you're at the starting page here. You click on the start here. That brings you here. You go through all this stuff. Then you click here. That brings you to continue to the next page. Sorry, that's where it is. Then it brings you to here, and then you're going through all this. So again, the site's a little bit difficult to navigate if you're trying to look for something. If you're trying to look for like one thing, it's very difficult to go find it. Like say, oh, I need an example for how to do a court of record. Well, that's not exactly how the site works. But he does have certain ways to search the site, but I'm just showing you how to flow through it, right? So then we've got jury, aspects of how to do jury things, and United States versus Williams is an extremely important case because it explains the fact that we have the right to form a grand jury anytime we want to. U.S. versus Williams with highlights, grand jury history, power of the grand jury, some of New York common law grand jury facts by Eric Williams, and some of this, if not all of it, is all covered in the grand jury classes, which you can find at the VSOF. If you come down here to playlist by quads of free classes, come down here and make sure that you click this once, the little button, and the grand jury information classes are the first one after you click the button. So if you want to know about grand jury, that's where you want to learn. We have available at the VSOF. So petite jury trial information, handbook of jury. This is all jury stuff. So how to handle the jury, how to work them, how to know who qualifies, who is and who is not a peer, right? So that's all that. Essays, a lot of essays in here for miscellaneous stuff regarding information. Obviously, this will take a long time to go through. I don't even think I've read all of this, but it's a good place to come and grab all this information and then just stick it into a folder for later reading, or if you want to do something on a Sunday afternoon. Transcripts, this is analysis and court case analysis of counterclaim for the transcripts and aspects of the seminars that he's done, some law humor, other links, reference law books. This is some links, I believe, to Black's. So here's all your law links. Good places to go grab stuff. United States Code link is here. Statutes at large. Act of Confederation, United States before it became the present day Constitution. Northwest Ordinance, so you have all your fundamental documents here as well. And judicial immunity, that they don't have it. Land patents, some information about land patents. And that's pretty much this little section of that site. So then after you get through that, then I would come all the way back to, once you're done with all that, then you come back here to the overview, and basically the overview just takes you down to the bottom part of what was underneath it, which was just down bottom here. And then you go through the 4 pillars. And the 4 pillars are actually where I personally would start, because they're very short. The rest of everything I just showed you was kind of difficult to get through in navigation wise. But here's the 4 pillars. History. So you click here. American law, a thumbnail sketch. So this gives you a good history of law in general. It's not as extensive as my all-day lecture on the history of law, but this is a good quick overview of how Rome was established, how the Magna Carta came in, Rome's rule over Britain, a good before and after understanding of what the Magna Carta changed about how the hierarchies worked. Again, the Carta Cartarum, what happened in the Revolution, so on and so forth. So that's a good little overview for history. And again, these pillars are fairly short here. Sovereignty, another thing about sovereignty, so you can go through this. We've already covered some of these things basically before. And it shows you, because I've already clicked on some of these things, they turn purple, right? So just to kind of help you navigate. And just a short read on sovereignty as far as the preamble goes, which I kind of covered before. So that's the next pillar. And then next is the Republic. Republic versus democracy. Again, very short. And again, you can download that Army manual. Court. What is a court? Common law courts of record. Magna Carta. Again, just a good short overview. And then last one is the corruption of how they're corrupting everything. And read the Anti-Government Movement Guidebook, which is also available in the VSOF online library, and some other reading as far as what they're doing. Now, this one is an extremely important one as far as understanding what the Norman Dodd and the Reese Committee did in looking into foundations. Basically, there was a time where the Congress said, well, all these big, huge foundations are doing a lot of various different things. You better look into it. And what I mean by that is the Carnegie Endowment, the Rockefeller Foundation, the Bill and Melinda Gates Foundation, right? All of those things had been looked into, and yet still there hasn't really been any action taken. But the Reese Committee really lays out what these people are doing in these enormous foundations. So, important thing to understand about the corruption. Okay, so that's pretty much it. That's pretty much all of 1215.org and how to navigate it and what is available inside it. So that's been the VSOF Saturday Night Civics and Sovereignty class. And again, we start usually at 7 o'clock. And we usually end up at 8 o'clock, but obviously we ran a little bit later because of having everything laid out going through the 1215.org website. And again, it's easiest to follow us on the live stream on Odyssey. And again, if you'd like to go to the Vocational Science of Freedom Odyssey, it's odyssey.com/@VSOF:8, and you'll be able to follow along on the live stream on both Wednesday and Saturday nights. So I'd like to thank everybody for coming and showing up tonight. And I like to thank everybody for listening and learning. So until next time, stay safe and stay sovereign.